Thank you. Please be seated. Good morning. We're here for oral argument in case number 1 CACV 16-0294, ABC Sand and Rock Company, Inc. versus Flood Control District of Maricopa County. Council, I would remind you that these proceedings this argument is being video and audio recorded, so if you'd please identify yourselves and your clients at the beginning of your argument. Each of you will have 20 minutes. Counsel for appellant, please watch the clock and reserve as much time as you desire for rebuttal. Also, please keep in mind we've read the briefs. We've conferenced the case this morning. Without counsel for appellant, you may proceed.
Janice Sutton. May it please the court, Janice Sutton on behalf of ABC Sand and Rock. There are three issues that we presented in this appeal. The first is the proper interpretation of the district's 2006 regulations. The second is judicial estoppel, and the third is the open meetings law, Arizona's open meetings law. I'd like to start first with judicial estoppel. While this is a kind of unusual factual case, we think this is a particularly compelling case for applying the judicial estoppel doctrine. Judicial estoppel is an equitable doctrine, and it has the purpose of protecting the integrity of the judicial process. Now here, members of the board, the individual members of the board, and this is a volunteer group of individuals that serve as the administrative body for the district, making decisions. ABC was involved in an administrative process. It then later brought a suit in 1983 in district court against the individual members of the board in their capacity as state actors for purposes of 1983. Before the district court, in front of Judge Wake, they said, "Judge, dismiss this case. We didn't hurt ABC. We haven't done anything to harm them. Look, we have this order. It says we ruled in their favor." Now that order is the order that was in 2011. Had no findings of fact, had no conclusions of law. There isn't really anything in the transcript to indicate what the basis for that decision was. So this was the first glimpse we had of what the basis was for their decision. They said, we ruled in their favor. They haven't been harmed. Don't worry about it. And Judge Wake adopted that position and said specifically in his order that the board ruled in 2011 that ABC's permit was valid and in effect. Now, if we stopped there, if that was some kind of misunderstanding, a misstatement at oral argument, something that could be justified in some way, we could stop there and say, does judicial estoppel apply? Maybe it was all misunderstanding. But ABC appealed the decision. Judge Wake dismissed the case. ABC appealed the decision to the Ninth Circuit. In its briefs to the Ninth Circuit, the board members represented to the court, look, Judge Wake got it right. Here, the board ruled in ABC's favor. It found that the decision, that the permit was valid and in effect, and the district court was right. You should dismiss this case. They have not been harmed. And the Ninth Circuit summarily affirmed the district court's decision.
Ms. Sutton, we know from the first appeal in this matter that the board and the district are two separate entities. How does that affect the judicial estoppel argument?
I don't believe it does, and let me kind of move into the next part of this. In Arizona, there are kind of three factors. They're not elements, they're not hard and fast rules, but there are three things that the court needs to consider for judicial estoppel. And the first is, are they the same parties? Here we are saying that it's not the district that's estopped, it's the board itself that's estopped. They were the parties in the previous litigation. Here they are the adjudicators. So they are, while they are not in the same position that they were in district court,
they're not a party in this proceeding.
They're not. They are the adjudicators in this proceeding.
That's why I'm having a disconnect there.
Right. Well, it is our position that while they are not in the same position, they are, there's a more compelling reason here than if they were just parties in this litigation. They are the adjudicators in this litigation, and if anyone has a responsibility to be candid to the federal court or any court, it is someone that is later serving as an adjudicator against the same party they were litigating against in another case. If we need impartial courts, if we need impartial administrative bodies, this is exactly the right vehicle for that. And as the Supreme Court has said, that New Hampshire versus Maine case, this isn't a strict doctrine, it's an equitable doctrine. fairness comes into play. And like I said, this is an unusual set of facts. You're probably not going to see this I hope you're not going to see this very often, where you're litigating against someone that's later your adjudicator, and that's how they are the parties are related. But here, if the goal is the integrity of the judicial process and we want people to be candid and not play fast and loose with the courts, this is the type of party that should certainly be precluded from representing one thing, turning around, and issuing a completely contrary decision.
On remand, could you have moved to recuse the board members?
There isn't a mechanism, and to be frank, there's just not a lot of procedural mechanisms at play. In the administrative proceeding, they are appointed. There's regulations and statutes on it. I don't know who would step in if they were recused.
The problem I'm struggling with your estoppel argument is this: that it was not definitive. I mean, yes, they took that position. Okay, but what other position were they supposed to take? I mean, what other position could they have taken? I mean, just say, yep, we're liable for millions of dollars in the 1983 action. I mean, they raised the issue because it had not yet been litigated. It was still being litigated. It was still litigated in this court. What, correct? At the same time it's going on in the district court, the issue of whether there was a valid permit was still being litigated in state court.
Well, the issue, they had issued a decision on whether ABC had a valid permit.
Correct.
They were the only ones who knew what the basis for that decision was, and from the face of it, they ruled in ABC's favor. ABC argued that it had a permit. We thought that they agreed. They represented in court that they agreed. They had other reasons. They have, judicial immunity. They have other defenses. They have the defense that they weren't arbitrary and capricious. They have plenty of defenses in the 1983 action. They aren't just going to roll over and say, sure, judge, fine me millions of dollars. They have lots of defenses. They can't make one that's false. And if they make one that's false and they are successful in that claim, they can't turn around and say, oh, we were just kidding. I mean, that was convenient at the time, but now that we have to actually explain ourselves, we're going to pull a 180. We're not trying to tie their hands in district court. They had lots of defenses. They made lots of other defenses. The litigation didn't get very far. I'm sure they would have had even more defenses than we got to see. But that brings to the other factors. We talked about them being the same parties. We talked about the question being the same, and the question is, did ABC renew its permit? And the last part is, was the district successful? And success is measured by, did the court adopt the party to be a stop's position? And here, Judge Wake did. And then they doubled down and said, yes, Judge Wake was right. This was our position. And the Ninth Circuit, again, affirmed dismissing the case. Now, there's another factor that's kind of been mentioned, although kind of in passing, and about whether it's a significant factor in the court's decisions. And our position is that if that's a requirement, then yes, this was a significant factor. Judge Wake specifically articulated that at that point of time, at the time that the board issued its decision, the board had ruled in ABC's favor, therefore nothing bad had happened to ABC, and the case was not ripe at that time. He then goes on to explain why it didn't later become ripe, but that was an important part of the decision. They latched onto it for the Ninth Circuit and again said, yes, this is important. We ruled in their favor. They had a permit. We shouldn't proceed in this court. So I'd say, yes, it is a significant factor, if nothing else by their own admission in citing it and relying on it heavily before the Ninth Circuit.
And just to be clear, back to not being the same party, it's your contention because of the unusual nature of party / board being the adjudicator and a party in the two cases, that's what creates the same party prong of the analysis?
Yes, to the extent there's a mutuality requirement, I believe we cited in our brief that it's not completely clear in all Arizona cases whether you always have to have the exact same parties. Right. Here, yes, that it is satisfied by the fact that They were parties, clearly, in the past litigation. They are both involved in the same litigation here. The fact that the party is now the adjudicator gives them, if anything, a heightened responsibility, not a lesser one. All right, and moving on to the district's regulations. To date, and we're coming up on 7 years here, to date, it is still unclear what ABC needed to do to renew its permit in 2006. Now, the district seems to oscillate between two different positions. It either says something more than a renewal fee, maybe something more than a renewal fee in an application, but certainly more than the renewal fee. And then in the alternative, they say, well, we can just do whatever we want. We could have just asked you to submit, the birth certificate of your firstborn child, and we can ask for whatever we want. If the regulations just say we can ask for additional information and we can ask for whatever we want, there's no limit on our discretion. The board kind of adopted the first position. They said in there, when they finally issued findings of fact and conclusions of law, they said, well, it's not enough to submit a fee and an application. You have to abide by the regulations. And then they cite to the wrong regulations, and it's still not clear what ABC actually needed to do to renew its permit in 2006. You look at it and you think, well, maybe it's reasonable. Maybe they needed to do more than submit a fee. But then you look at the other findings and conclusions in the board's decision, and it says, well, the regulations, they got more rigorous as time went on. It used to be really easy, and then they got harder. Well, it turns out, the change in the regulations happened later, so it's not clear how that happened. At the end of the day, ABC is still sitting here looking at the regulations going, well, there's nothing specifically that pertains to how you renew a permit. The district is now saying, okay, so the process for applying for a new permit is the process for always applying for a new one. You have to let the old one expire and then always apply for a new one, except that there's different fees for it. None of that is clearly spelled out in the regulations, and to be frank, the board's decision doesn't really shed a lot of light on it. We think, based on the scheme of the overall regulations, it's clear that it was a summary, submit the renewal fee, and your permit continues to go. If you need to change your permit, if you want to dig deeper, if you want to do something different, if you're out of compliance, there are different procedures for dealing with those issues, but as long as you just want to do the same plan, just keep going the way you're going, you're still within your limits, you're still just digging and selling rocks and doing all these things, you just submit the next fee and you get your next 5 years.
What's the purpose of the fee?
I believe it's to pay for the inspections. We've cited to some of the regulations that imply it's to pay for the inspections and the compliance aspect. It makes sense to have an ongoing fee to pay for some of these administrative costs.
I agree with you that the regulations certainly could be clearer back in 2006 about renewals, but is there an argument based on the definition of floodplain use permit, which defines a permit as a permit that must be obtained prior to commencement or continuance of any non-exempt use? Can you use that definition to say, well, it's within its discretion to apply whatever initial permitting requirements it deems appropriate in a renewal situation? Because the use permit is defined as two-pronged, commencement or continuance.
Correct. I believe the answer is no. And let me step back. So it is, you need a permit for the commencement or continuance of work. They're basically saying, you don't just get a permit at the beginning and then it's valid forever. You have to have a permit that continues to be in place. A permit is something they check up on continuously. They inspect, they do things.
But then that dumps us directly into Section 5 of floodplain use permits, which is where they deem their authority arose under the 2006 regs. I mean, it dumps us into that both for the initial and for the continuance, I think.
I disagree that it takes it back to that application process I might have to look at it when I come back. But I do believe
you can talk about it.
Right. I do believe that you can have the need to have a permit for the initiation, for the continuance, for all time. You just have to have a permit. Here's what a permit is. Here's how you get one. And then have a separate process for how you renew one, just like there's a separate process for how to amend one. All of this is made much more clear when they amend the regulations in 2011, that there are these three separate processes. It's just less clear here. But based on the overall context, I think you can get the feel for, yes, you always have to have a permit. You have to get one to initiate. You have to get one to continue. But you get one at the outset, and then there are different processes for either changing or continuing along with the same one. And it's not going to be this crazy rigorous process where you have to get topographic surveys and engineering reports and all this stuff. If all you want to do is keep digging the same hole that you've been digging for the last 5 years. So with that, I'm going to reserve the remainder of my time. Thank you.
Thank you, Your Honor. If it please the court, Steve Tully on behalf of the Flood Control District of Maricopa County. Your Honor, in February of 2011, the Flood Control District informed ABC that if its permit was not renewed, mining would need to cease at the termination of its current permit on May 14th of 2011. And in April, the district...
Can I go off, potentially off record for a minute? But that, if it's not on the record, then you don't need to respond to this. But does the ABC have a permit to exist, to operate today as we sit here?
As we sit here, they have a permit that was received in August of 2017.
Why isn't this case moot?
Well, I'll jump ahead then. That was in my
Go ahead.
Okay, because I assumed you would wonder why we're not here since they weren't fined. And the reason they were here, I believe, is that what happened was ABC never did what was required to get a permit after this, and there was a subsequent enforcement action after the Board of Hearing Review ruled that they didn't have a permit. One more on appeal for today. So in 2015, January of 2015, the order from the Board of Hearing Review comes out, and ABC doesn't get a permit, doesn't do what's required to get a permit, and another enforcement action is required by the district to get ABC to comply. And then in that action, the Board of Hearing Review actually fined ABC, issued fines to ABC, and subsequently, after after a long period of time, nearly 2 years, 2+ years, ABC did file the necessary engineering and other documents to obtain a permit. But there are fines out there, and so ABC, I believe, for all of most of 2015, all of 2016, and most of 2017. And so what ABC, I believe, the reason why we're here is that ABC, if this court were to find that they had renewed their permit in 2011, it would have run through 2016. And they would have then, presumably we'll try to make an argument that somehow that they shouldn't be fined for that period of time in 2015 and 2016 when they should have been considered to have a permit.
Okay.
All right, let me jump ahead since a little bit here. Essentially, the district notifies them that they need early in February of 2011. Hey, your permit's going to expire in May. In April, they send them a list of items that they need to complete the process, right before the expiration date in early April. This is all on the record. And ABC refuses to provide those documents. Doesn't provide the documents. In May, the district sends them another letter and says, "Look, you have to provide us these documents. We're not going to issue a permit. And by the way, if you don't provide these documents, we won't issue a permit. And you need to cease operations. It is illegal to operate without a permit. Your permit's going to lapse. You're not going to have a permit. You can't operate." ABC continues to operate, and even though it doesn't supply the documents, just continues to operate. And so the district then has to bring the enforcement actions for which we're still here today. It's been appealed. The Board of Hearing Review issued its order, and then that went on these appeals. Now, in these arguments, in that case and before this court previously, the ABC argued that it ought to have been considered to have a permit under what it referred to, what its arguments below was that it, by course of dealing, it had a course of dealing permit.
Can I interrupt? Because I'm afraid
Yeah.
you're going to run out of time.
Yeah,
I've got lots of questions on things.
Sure.
And I was on
Let's
that
go.
panel, and I agree the course of dealing argument's dead law of the case, and I don't even really hear them re-urging that.
Okay.
But what I'm interested in is you make a statement in the answering brief that the district did not have different requirements for renewing a permit than for those granting new permits under the 2006 regs. So can you walk me through the authority under the 2006 regs for basically requesting the information your client requested?
Yes, Your Honor. Sure. Under Article 5 of the 2006 floodplain regulations, under section, which is the floodplain use permit section of those regulations, section 502, it's entitled Application Requirements. Right? And it states, the applicant shall submit any information that the floodplain administrator considers necessary in making determinations required by these regulations.
You're exactly right, but I guess the underlying question before you reach that language is, what's the authority in these regs for saying that applies to renewals as well as initial applications?
Well, a renewal is a floodplain use permit.
Gets back to the definition that I was asking Ms. Sutton about. A floodplain use permit is for commencement, which would be the initial, or continuance, which in your view would be the renewal.
Yes. I mean, both state and federal law require that you have a permit to operate in the floodplain.
I mean, would you agree with me that the word renew is nowhere in the 2006 regs except for the fee schedule?
Well, I mean, I haven't read every.
mean,
I don't know. I haven't read every regulation for that. So I mean,
to hone in, to follow in more
but-
on my concern here is that the trial judge, Judge McClellan, said that his direction on remand was to have the board state, as a matter of law, what an entity in the position of ABC must do to renew a permit. And I don't see that reading the board's. I mean, help me understand, what did the board answer that question? And if it did it rely on the 2011 regs in doing so? I mean, just what was ABC supposed to do exactly?
what ABC was supposed to do was respond to the requests, just like they do now under the new regulations. What happens is they file an application, they file a fee and an application, and then if the district has engineering comments, they send those to ABC. ABC responds to those, provides the documents, provides the engineering analysis or the topography if it's necessary that the district needs to see if they're complying with the regulations and if they're operating in compliance with the regulations and therefore are able to issue them a permit to continue operations. So, I mean, without getting, with factual stuff that which is in a record or not record, ABC was out of compliance, and so the district needed to find that out. So they're asking for information to determine, in 2011, they were actually out of compliance with their old permit, and they're trying to find that information out. So they're asking them for that information, and this statute, this regulation, specifically allows them to ask for the information they need to do that engineering analysis.
So a little legislative intent here. What was the purpose of the 2011 regulations if it was all adequately covered in the 2006 regs regarding renewals?
Well, it's to make it clear. It's to they make various changes to the regulations.
Doesn't that cut against your client a bit? That would be saying that it was unclear. Then there was at least a bit of it was unclear.
Here's the thing. I'm not sure it's relevant, Your Honor. Here's why. The law required ABC to have a permit to operate in the floodplain. And the regulations permitted the district to ask them for information, and that ABC had to provide that information in order to get a permit. ABC didn't provide the information and didn't get a permit. Now, ABC, it is not an excuse to the enforcement action that ABC should have been issued a permit. That's not an excuse, right? If I go to the DMV and I pass the test, but they score it wrong, I don't get to drive around town until somebody pulls me over, and then they say, well, you're driving without a license. And I say, well, I should have been issued one. Let's go relitigate it. They're two separate legal issues. Operating without a permit is a violation of the law. And whether or not I've done what is sufficient to have a permit is a separate legal question. And by the way, that's why they made up this new argument today, and they didn't bring it up earlier about that they satisfied the requirements for a regulation, and didn't bring it up earlier because it wouldn't have been an excuse to the NOV to come before the board and say, hey, I should have been issued one. Well, that's interesting. It's a separate legal issue. The question is, you don't have a permit, none was issued, and you can't operate. Now, go fight the issue about whether you should have had a permit or not separately, but you can't. There's no self-help in the law. The law doesn't say, hey, if the district doesn't give you a permit, go ahead and operate, and if something comes up, you can go fight it later. That's not a legal excuse. And so that's
sought mandamus relief in that setting, saying that the chief engineer or whoever it was at the time was exceeding the scope of his authority under the regs.
They could have taken some legal action, I suppose, to determine whether or not the requirements, but they didn't, and they didn't even make that argument because they knew they had to provide that information. They didn't make that argument at that point. At that time, what they argued was we have a course of dealing permit, so we do have a permit. They didn't say, we should have had a permit. They said we did have a permit, and the court ruled they didn't have a permit. So now on appeal, the first time, by the way, they didn't argue this to the Superior Court. They didn't argue this down below. First time is today in this court is they're arguing, well, we really all we need to do is file those two things, pay the money and submit a one-page application, and that was sufficient to get us a permit. But that really, but that's one reason why this court, should not even be considering that argument today. But that's not because that's not a valid. It's a new argument. It's not a valid argument. I'm sorry.
Estoppel.
Estoppel.
Talk to us about
okay,
estoppel.
I'll talk to you about estoppel.
How do they get to be a party and the judge at the same time?
Well, Your Honor, first off, I represent the district, which is today here in this court. Now, before they didn't actually bring an action, 1983 action against the board. They did name a number of individual members. So you have a difference of the parties there. But really, I think the key issue, or a number of the key issues on this is that, and I'm going to get to my arguments on that. Is to understand what we're here for today, and the Superior Court issued an order confirming the Board of Hearing Review's recent order that ABC did not renew its permit in 2011. That's the order that's on appeal, right? The district's understanding of what the Board of Hearing Review meant by the board's vacated previous order is irrelevant to the question of whether the board's current order today is valid. So, it's not even this judicial estoppel claim is not even relevant. What the district might have interpreted their order to be is not binding. Their order is what it is. Now,
the district or the board. I mean, are you conceding that the parties are the same? I'm not real clear.
No, I'm sorry, Your Honor. And by the way, I think you've switched your name cards.
The tab was wrong on the door.
Believe
me, I want to correct that.
All right. Am I right there? I think I'm right there.
You're right.
Yeah.
I remember golf courses and wet grass. So
I'm not conceding that. What you have is first of all, and it's not identical parties because there's different members on the board now of hearing review than there were, I believe, at the time that this initial order was done back in 2011. So it wouldn't be exactly the same individuals even that were making the decision.
But
So
the district was a party to the federal court proceedings in addition to the board.
the county, my recollection is the county and that. But if I
Your
could,
primary argument is that the issues were different. In the federal court action, it was basically, has ABC suffered a cognizable injury? Here, the issue was the board's action.
right, and I don't even we didn't even concede the facts. I mean, in Neil Wake's order, if you read it, he doesn't say that they found that there was an order. He said, if you read the actual full order, he's reciting what they take out is a portion of the order where he says facts, alleged by the plaintiffs and deemed to be true. And then he says these are things. So these are the facts. He's reciting their facts. He states right in that order that this issue is being litigated. Because remember, the appeal from the district to the Superior Court occurred before they filed the 1983 action. Obviously, the board has always and consistently said, the district rather, has always and consistently said, you don't have a permit. And so it's always been the district's position that we didn't issue a permit, you don't have a permit, and you didn't comply with the permit. And that was litigated before the 1983 action. The 1983 action, and if you look again, they have it in there, the brief from the Ninth Circuit. Look, all you need to do is read the issue as it's described by the district to the Ninth Circuit Court. It doesn't say anything. Whether or not they've been issued a permit is not in there. What it says is that issue is being litigated, and until it's decided, right, and it's still being litigated today in front of this court, until it's decided, it's not ripe. You can't claim that we didn't give you a permit when you're telling you had a permit. Until the court finally says you didn't have a permit, how can you sue us for wrongly not giving you a permit? It's the fact that it's being litigated, not the actual finding that you had a permit, that makes it not ripe. And so it's factually the factual claim that it applies is completely inaccurate. And by the way, they filed another 1983 action since that time, and Judge Tucci dismissed it for the same grounds just this last summer. So they tried again to file a very similar case. So, I mean, all these arguments are available. So they keep, serially filing ones, and I find it very, bizarre for them to suggest that somehow because they take, improperly file actions that somehow the board is stopped from inequity from doing its duty and explaining what the law is. So judicial estoppel doesn't apply. I've only got 3 minutes left. Do you want me to address open meeting, or I can address it?
Well, yeah, as to the open meeting issue, is the right parties, again, the party issue. I mean, this is an allegation that the board of review, or the hearings board violated the open meeting law. Are they they're not a party to this?
Exactly. Well, yeah, correct, and I've cited that. I don't think that they're under the statute. I think that they would need the proper way of addressing that was to bring a claim against the Board of Hearing Review and said you violated the open meeting law. But we don't think that they violated the open meeting law. I mean, the order that was issued in this case is just, it goes back to the appeal. It's the decision in the appeal to the Board of Hearing Review. That's what's doing, and ABC had a full-blown hearing on that issue, on the issue of whether or not they had on whether or not the chief engineer's order should be upheld. Right? They had a full hearing, and they had discussion, and their attorney talked, and there's a transcript in there, and so the order coming after that. Now, when we came to the order, the counsel for the board actually asked the parties, how do you want to handle it? And ABC said, we don't believe you can take testimony. We don't think you can review the record. We don't think you can do anything. You just have to issue an order. And that'll be in the record. So they filed a pleading that said that. And so the district, the Board of Hearing Review issued an order, didn't actually agree with them. It did review the record, but they haven't appealed that issue. And so they issued They had an order drafted, and they had an open meeting, and they voted on the order. And ABC's attorney was there, and she wasn't clear what they were, she asked a question about, what did you just vote on, but she made no objection to it when they voted the order out. And, the order was created by their attorney. It was drafted by their attorney. Boards, to suggest that a board's going to have some sort of work session when it's trying to scrivener an order after they've had a full hearing on the appeal, I think is practically impossible. I mean, they'd be running back to their attorney constantly. I think most boards, they have the open hearing meeting, they had a full appeal hearing, and when it comes to actually drafting the order, they ask the attorney to do it, and then they vote on it. There is no, they seem to suggest that there's sort of a level of dickering that must occur amongst the members about what's in the order in public meeting, and there's no judicial standard by which you can determine whether they talked about it enough. They talked about every item on the order before they voted it. I mean, there's just not a standard from which you could apply that. So, we don't think that's a valid thing. We don't think sending this back for another round of appeals is worthwhile. Sorry, we're out of time.
Okay, thank you.
Briefly on open meetings law, there does not need to be the board as a party here for the court to void the order. The order is up on appeal. The court has authority to void it if it violates the law, which the law says if it violates the open meetings law, it's void. The reason there's a separate procedural mechanism for bringing it up to a public body that, hey, you violated the public meetings law is because not all boards are adjudicative bodies. Not all of them would you appeal from their decision. Maybe they're buying land. Maybe they're negotiating something. There's lots of public bodies. They do lots of things. This happens to be an appellate body. So there is this mechanism that we can come to the Superior Court, we can come to the Court of Appeals and say, hey, it's void. They violated the law here.
That deprived them of their right to ratify, which the statute clearly gives them. By making a collateral attack, that forecloses the ratification that the statute contemplates being available.
The statute contemplates that they can ratify it within 60 days of when 30 days, within a certain number of days after they knew or should have known of the error. Maybe they shouldn't have known until this court ruled that they violated the open meetings law, because the law in Arizona is a little ambiguous on this point of what does an adjudicative body really need to do on the record. Or maybe they should have known, and maybe they can't ratify them, or maybe they can because you'll say, oh, there's no way they could have known that we were going to rule this way. That kind of thing happens. So I think it precludes them from being able to ratify. The standard is pretty clear in the statute what their limits are on ratifying their decision. Going back to estoppel. So in their brief to the Ninth Circuit, opposing counsel says that they just said, oh, don't worry about it. It's still ongoing litigation. We don't know what's going to happen. We'll just have to wait and see. That did come up I think we're getting kind of cases confused. That was an abstention argument that was litigated elsewhere. But I'll read their brief. Page 11. This is in the record at Appeal 285. But as the district court observed, the review board ruled in ABC's favor and found that the February 2011 renewal of the Plant 1 permit was valid and in effect. Plaintiff's Plant 1 permit was found by the board to have been renewed, and plaintiff continued to operate. It's a whole paragraph that they devote to saying, look, we sided with you. We ruled that you had a permit. You haven't been deprived of a permit, so that due process right that we were fighting over of whether we've been deprived of an interest, a property interest. They said, no, you haven't been deprived of property interest. We held that your permit was valid. And they dedicate this entire paragraph to it. So it's misleading to say that they did not rely on that ruling. And finally, going back to the regulations, so I did take a look at the definition, and I think my interpretation of that definition of floodplain use permit, it says that it's required for the commencement and continuance of the use in certain specific ways. It's basically the same thing as saying engaging in development, which I think is how the later one is.
Prior to
Right.
commencement or prior to continuance.
Right. And it could say prior to engaging in, I think would encompass the same kind of concept. I think that they meant to convey that you don't just get it once. And sometimes these mines stop. There's a way to kind of pause your permit for a while and then come back in. There's weird things happen. This was in 2006 when they amended these, and a lot of these places went out of business and stopped for a long time and came back in. So maybe they just wanted to make clear that if you were engaged in this and you did this for 30 years and you stopped because the economy went down, you can't just pick up where you left off automatically and say, well, I only used 2 years of my permit. I'm going to continue my remaining 3 years with this gap in the middle. If you're going to continue, you need to get a permit. Once you have a permit, it all comes down to, I think, a very clear difference in where we're coming from. Opposing counsel said ABC was out of compliance. There are regulations. There are statutes that say if ABC is out of compliance, there are processes for bringing ABC back into compliance. There are processes for finding them if they're out of compliance. The option is not just to deny them a permit and then fine them for operating without a permit. They can fine them for operating out of compliance. They can get an injunction in Superior Court if they're operating out of compliance and risking anyone's health. They have options. If they decided, they looked at ABC and they said, you're out of compliance, they had a whole procedure that has different remedies and puts the parties in a different position. Instead, they said, oh, we're just going to require you to submit all this stuff like you're submitting a new permit. I don't care if you said, which it says specifically in ABC's letter, which is included in the record, of when ABC tried to renew its permit, submitted a letter saying, you know, I really need to dig deeper, but I'm not going to. I'm just going to ask you to renew the existing permit. And we'll work out changing it later. I just need the 5-year extension. That's all they wanted. Why go through all this expensive engineering process if all they wanted was to dig the same hole? If the district's position was the reason we needed them to do more is because we needed to know more because they were out of compliance, there were processes for that, and they should have gone with those. Thank you.
Thank you, counsel. Thank you both for your arguments. The court will take this matter under advisement and issue a decision in due course. We'll take a minute for a brief recess to prepare the courtroom for our next argument.